On behalf of the Corporate Law and Financial Regulation Program of the Melbourne Centre for Commercial Law, I'm delighted to welcome you to tonight's seminar by Emerita Professor Pamela Hanrahan. I'll begin by acknowledging the traditional owners of the lands on which we're meeting today. For those attending in person, we're meeting on the lands of the Wurundjeri Woi-wurrung people of the Kulin Nation. First Peoples have upheld their laws on these lands for generations, and I pay respect to their elders, past and present, and extend that respect to other custodians. Emerita Professor Pamela Hanrahan is an Emerita Professor of Commercial Law and Regulation at the University of New South Wales Business School and a consultant at Johnston Winter Slattery in Sydney. She's the chair of the Business Law section of the Law Council of Australia, a member of the Corporate Governance National Committee of the Australian Institute of Company Directors, and a member of Connexus Institute Advisory Board. Dr. Hanrahan has written widely on corporate law and governance, securities and financial markets regulation, and the law of collective investments. I won't list all her many books, but themes in her extensive collection of referee journal articles and books include the liability of individual corporate officers implicated in corporate compliance or disclosure failures, and the growing use of civil penalties in Australian business regulation. Pamela is also a former Regional Commissioner of the Australian Securities and Investments Commission and the immediate past chair of Landcom Corporation, and co-host of the commercial law podcast, The BLS Report, as well as author of the monthly column Directors Council in Company Directors magazine. But the topic of Pamela's presentation tonight is liability for mandatory corporate disclosure in Australia, the case for simplification. So without more, I'll hand over to Pamela.
Thank you and good afternoon, everyone. It's such a pleasure for me always to be at Melbourne Law School. As you know, I was a faculty member here. I was also a student here, and fun fact, both of my parents went to Melbourne Law School and my grandfather. So it's a very special thing for me to be back from Sydney and back in my alma mater talking to you today about a topic that I feel very strongly about. So no language warning, but there may be an enthusiasm warning coming. You'll see the tranquil waters of corporate disclosure in Australia. We'll see how we go from here. All right, so what I'm going to talk to you today about is the liability that corporations and their officers can have if there's a problem with the disclosure that the corporation makes. And I'm going to talk about three specific types of mandatory disclosure in particular. So this is about saying if there's a misstatement, so a half-truth or a falsity in a statement that's made by a corporation, or if there's an omission of something that ought to have been disclosed, then what happens as a result of that? And we're going to talk about criminal liability, civil penalty liability, and then civil liability to affected individuals in the form of damages. So that's what this is about. And I know you're all thinking, terrific, just what I was hoping for at 5 o'clock, 6 o'clock in the evening, talk about mandatory corporate disclosure. But actually this is, if you reflect on how much time is spent in the courts on corporations matters, disclosure failures are actually the single biggest type of contested corporations work that happens, not just in our jurisdiction, but if you think 10b5 actions in the United States and so on, like a lot of what passes for corporate litigation in particular is actually about disclosure failures. And even when you think about famous cases in the Australian jurisprudence like James Hardie, now people, if you went out into the street and asked people about James Hardie, they'd say, oh, that's a case about not protecting people against asbestos. It's not, it's actually a continuous disclosure case. So it's a disclosure failure case. So sometimes I talk about corporate disclosure as being like a gateway drug. It's a bit of a gateway drug to, complaining about corporate behaviour. And if you think about greenwashing and all that kind of sustainability disclosure and so on, you'll see that it's actually really important. Now, its importance leads me to argue strongly that we ought to have an effective corporate disclosure law. That disclosure law ought to make it very clear what people are supposed to disclose and then what consequences will follow if there is a failure in that disclosure. It needs to be efficient, it needs to be effective, it needs to be capable of being complied with and capable of being enforced in a sensible way. And my thesis tonight, and you can see at the end if you agree with me or not, is that we don't have that in Australia. So my argument is that the current law is incoherent, and I use that in the technical sense. And that's one thing, but the point is that incoherence not only annoys my slightly engineering brain, but it's harmful in the sense that it makes compliance and enforcement more difficult and costly than it should be. And because it's not principled, so you can't explain as a matter of principle why the liability rules work the way they do, it encourages gaming behaviour. So people game the system when they're thinking about their disclosure. It confuses the hortatory message, which just means it doesn't make clear to the regulated population what principle it is that they're supposed to be following. And it negatively impacts on regulatory legitimacy because people look at this, by people I mean non-lawyers, look at this bowl of spaghetti and just say, well, that's your fault and all lawyers should be dealt out of the conversation. And we can talk about that being perhaps the most damaging aspect of what I'm going to talk about today. So I'm going to talk about the liability rules that apply to 3 types of mandatory corporate disclosure for reasons that will become clear. The first one is fundraising disclosure, the second one is annual reporting, and the third one is continuous disclosure. And what I'm going to argue for is policy clarity, right? So being able to explain in a principled sense when particular consequences should attach for disclosure failure, not just arguing for consistency for its own sake, although, as I mentioned, my engineering brain finds the lack of consistency really challenging and difficult. All right, so we'll talk about the different types of disclosure in a minute. First of all, for those of you, there are a few people in the room who recognise the lovely person on the slide here is my dog Louis. He has nothing to do with this speech other than that he's very cute, and if you haven't considered rescuing a greyhound, you definitely should. So there you are. Anyway, he's got his ear up because he said, well, you better give them some context at the beginning. So many of you know that I have kind of strong views on aspects of the way business regulation is designed in Australia, but I'll put those out on the table and then we can talk about them later. But it will be helpful for you to understand where I'm coming from a little bit. So the first is that I think there's a very strong case for a systematic corporate law overhaul in Australia, and I've called that corporate plus law because, of course, part of the problem that we have in Australia is that our corporate law, in the true sense, is enmeshed in a much bigger kind of area and it lacks coherence in its design. So I think we do need a new corporate law in Australia, and corporate disclosure is part of that law. So I'm starting from that position. We'll talk about how realistic that position is in a minute. When we do that, I will say 2 things. The first is I think we absolutely should break up what I refer to as the omnibus statute. I refuse to call it the Corporations Act anymore because it's not that. And in fact, there is a written version of this paper, and in it, my co-authors always note that the jokes are in the footnotes, so you always have to read. But this statute, the omnibus statute, it is our corporations, securities, derivatives, takeovers, financial markets, collective investments, corporate insolvency, financial intermediaries, and consumer financial products and services statute. And then there's a footnote, and in the footnote it says absurd but true. So that's in case you're in any doubt as to what I think about the architecture. I was there in 1991. I know why it's structured for constitutional reasons in the way that it is, but it needs to go. It's ridiculous. The second thing, which is even more controversial and causes people to run screaming from the room, is we should break up the omnibus regulator. ASIC has too broad a mandate. Parts of its mandate are in direct competition with each other. And if you don't believe that, have a look at it, the very confused story it's telling about private credit at the moment. So on the one hand, it's supposed to be facilitating capital markets. On the other hand, it's supposed to be protecting retail investors. And guess what? As with the state mortgage in the 1980s, as with Banksia securities in the 2000s, we're now in a big private credit real estate bubble, and we'll see what happens next year. But anyway, not to be Debbie Downer or anything. Anyway, so I would break up ASIC into a financial consumer regulator and a securities and markets and corporate regulator. And that's not even talking about the registry, which is its own problem. And then, having made those two pieces of design or architecture changes, I think we then need to work systematically through corporate law. And I've said corporate law by cohort. We need to think about whether the distinction between public and proprietary, not-for-profit and profit, large proprietary, small proprietary, reporting entity, like we need to go back and think about which bits of corporate law should apply to which types of companies. We need to revisit that, I think. Then, of course, we need a new insolvency statute. We need significant work, I think, on our capital markets, securities and takeovers laws. This includes takeovers changes that have been sitting in the takeovers code for 30 years by ASIC instrument because nobody can ever actually enact them, those sorts of problems. Collective investments, including collective CCIVs, which were introduced and nobody's ever used, that all needs to be relooked at. And then, of course, the debacle, that is Chapter 7 financial consumer law in Australia, needs to be completely rewritten. So that's where we're coming from. All right, so Professor Godwin, who's in the room, of course, wrote an article that referred to the porridge. So here's the porridge. You'll remember that back in 2012, Stephen Rares famously described the Corporations Act as legislative porridge, and I'll come back to the porridge in a moment, but here's the porridge. That was in the Wingecarribee case, which involved the sale of CDs to local councils by Lehman Brothers. So we've always had this porridge problem, and the porridge problem leads to this. And I put the date on this slide because this is important for two reasons. The first is 24th May is my birthday, so you can make a note of that for next time. But 2014, so that's 11 years ago. And look at, Stephen made a speech about, at the Competition Law Conference around Commonwealth statutes in Australia and our tendency to have these over-particularised statutes, and he was critical of that for the reasons that I've put on this slide. So attempts at codification involving many permutations on a theme, it's inevitably complex and likely to miss something. It's the handmaiden of incomprehensibility, which is perfect. Unravelling complexity requires time and effort. More detailed and complex the legislation it is, the harder it is for the ordinary person to grasp the point and comply. Complexity makes litigation more difficult. It's harder, there's more that courts have to deal with, and of course that leads to delay and the greater likelihood of error and so on. So this was 11 years ago. Those of you who worked on the ALRC report, which I'll talk about shortly, will recognise many of these themes. But the point is that the complexity problem in the Corporations Act and in the Commonwealth statutes, business statutes in Australia, is not a new problem. And it's not just annoying for those of us who like order, it's problematic for all the reasons that Stephen's talked about and many other people as well. So how does that manifest itself? A case in point is the way we think about liability for mandatory corporate disclosure. So fundraising in securities offers, I've put securities in inverted commas. Justice Black and I write a book called Securities and Financial Services Law, which I can advertise is coming into 11th edition this year, which is very exciting. In that, there's a whole chapter that just deals with the definition of securities. And for those of you who don't work in the area, you may not realise there are 8 different statutory definitions of securities used in the single statute. So depending on the context, there are 8 different definitions. And sometimes it includes listed managed investment products. I'm a collective investments lawyer from way back. That was what my doctorate was on. So sometimes it includes managed investment schemes, sometimes it doesn't, and so on. But anyway, we'll talk about it just in terms of these. So when a corporation is offering to issue securities, shares, debentures, and let's say, for the sake of argument, listed MIS interests, it will need to produce some kind of disclosure that's required under the Corporations Act, and that disclosure will be Part 6D disclosure for you and me, prospectuses, right? But also offer information statements, short form prospectuses, shorter prospectuses, and various other old Tom Cobley that are never used. Or it will issue, if it's a continuously disclosing entity, it will issue what's known as a cleansing notice, and then it can do a low doc offer. It may want to raise capital through a crowdsourced funding offer, which is a different regime. Again, if it's issuing securities as consideration in a takeover bid, then the takeover law has a whole lot of disclosure requirements in the bidder statements or scheme documents. And then, of course, for listed MIS, they are covered by a different regime, the product disclosure statement regime, which applies when you buy a home insurance contract, you get a PDS. If you buy a listed MIS interest, you get a PDS. If you buy a listed investment company interest, you get a prospectus. Given up arguing about that, but anyway, they're securities. So we're going to talk about it in that context. Then we're going to talk about annual reporting. This has really become very important because for 150 years, annual reporting was just about the accounts and the director's report and the auditor's report. But now, of course, we have sustainability reporting as well, which is very qualitative in its nature. So a lot of people have started to think about the liability that might attach or the strategic litigation opportunity around disclosure in sustainability reporting. And I've just published in the Journal of Corporate Law on that this month. So you can see all the different ways you can sue people over their sustainability reporting, which no, Johnson Winter's slattery clients don't necessarily like me pointing out, but nevertheless, there it is. Directors report, ASX disclosures like the corporate governance statement and so on that go into the annual reporting and the auditor's reports. And then the third category, continuous disclosure. This is, of course, the obligation on listed entities and some unlisted entities to make real-time disclosure of material information subject to some exceptions under the listing rules. So we're going to talk about the liability rules that apply there. Now, this is the part of the presentation where you go, it's okay, there's a written paper, so I can get this later. And in the written paper, not even in the footnotes, in the paper itself, it says, I'm now going to explain how all these rules fit together, the liability consequences of a misstatement or an omission. And it says in the paper, and this bit's really boring, and that's the point, right? The point is that this is mind-numbingly complicated, and that is the point that I'm trying to get across. So you don't need to make notes, or you can just get them, and I've put them all in tables so you can look at the different provisions next to each other. First of all, we're going to talk about the liability of corporations. So the entity itself, if there is a misstatement or an omission from one of those corporate mandatory disclosure documents, what happens? The answer to that is there's 4 possible things, categories of things that can happen. The first is that there's a whole lot of context-specific liability rules. So there's one for takeovers, one for prospectuses, one for PDSs, one for crowdsourced funding, blah, blah, as you can see. And they typically have provisions that say, if there's a mistake in this, you're liable subject to a due diligence defence. That's basically what they say. They're all different, of course. They all have a different definition of materiality and a different, and sometimes the onus is on the prosecutor and sometimes you've got to establish a defence or there's a safe harbour. But basically there's some context-specific rules. And the history behind those was that right back in the early 90s, when they changed the prospectus laws, they introduced a no-fault liability rule for mistakes in prospectuses. And everybody said, no, don't do that, right? There should be a due diligence defence. And so that was kind of the default position for all of these regimes. Then we have strict liability misleading conduct rules, and they are typically 1041H, thou shalt not engage in conduct that's misleading or deceptive. 12DA, which is slightly different but substantially the same, and then 2 other provisions of the ASIC Act that I'm going to talk about at some length, 12DB and 12DF. They're all general prohibitions on misleading and deceptive conduct, but they work in different situations and they have different consequences. Then there's a third category, which are the old securities offences. So the securities offences were things like making a statement that induces people to deal in securities, and engaging in making representations about securities that are not accurate and so on. So they've always been offences. They came out of the old securities industry codes from the 1970s, the Ray Committee. Another story for another day. So there's that category. And then there's a fourth category, which is in the part of the Corporations Act, which is called offences. And it's a provision that says if there's a mistake in a document that's required under the Act, these consequences follow. So why is this complicated? Why is this complicated? The answer is the context-specific rules exclude some of the strict liability rules, but not all of them. And they don't exclude the securities offences, and they don't exclude the information failure provisions, which used not to matter because they were just offences. So nobody ever gets criminally prosecuted in Australia. It's too hard. And nobody at ASIC talks to this DPP and everybody's, evidence. So it used not to matter. However, now they're civil penalty provisions and they're no-fault civil penalty provisions. So we started back in 91 with just context-specific liability rules, and the default setting was if there's a mistake, you pay for it unless you can prove due diligence or reasonable reliance. And then over 30 years, more and more of these things got added to the mix. And so now this is what creates the incoherence, because in some places, as I'll show you in a moment, there are defences, in some places there aren't. There are differences around burden of proof. There are different definitions of what's material, and different consequences can follow. And then even, as you'll see when we get to this slide, even if you get to the point where there's a liability in damages to somebody who can prove that a mistake resulted in a loss for them, there are different rules around adjustment for damage. So each and every one of these rules operates with respect to the same conduct, but operates differently. So they're the fundamentals of the corporate liability rules. At the individual officer level, and as Elizabeth said, I've written a lot about this, the extent to which we use accountability of individuals to force particular corporate behaviours. That's what I'm interested in. There are different ways in which individual officers of a disclosing entity can be responsible legally for mistakes, depending on how they are implicated in that failure. So usually corporate disclosures are made by the corporation itself. So the direct, person engaging in the conduct is the corporation, but that's not always the case. Sometimes an individual officer will themselves personally engage in that conduct as well. And there's a whole series of really interesting cases about when people are both liable alongside the corporation, or whether they're just acting as the corporation, or whether they're liable and the corporation's not. So all those attribution cases are really interesting. But if I personally, as a director of a company, go to an analyst briefing, for example, and make a representation that's false or misleading, then of course I have direct personal liability for that. And the securities offences are the same. They apply to any person. The information failure provisions, these are really important for corporate officers. The first one, 1308, I've already talked about, is the provision that applies if there's a mistake in a document that's required under the Act. 1309 applies to an individual corporate officer or employee, and it is breached if they provide information to ASX, to the board, to the auditors, to the members, to the trustee, debenture holders, and so on. So it's a really important provision that it's intended to punish corporate officers who provide inaccurate information in the kind of corporate machine without having taken reasonable steps to ensure its accuracy. So that's a really important provision. Then, of course, typically we punish people whose corporations have made disclosure mistakes by suing them for negligence in one form or another. So if you can prove that the director's own negligent conduct was the cause of the mistake made by the corporation, then they're personally liable for that. 344 is the provision that requires directors to take reasonable steps in relation to the annual report, and including the sustainability report, and Section 180 is the general duty of care. So that's a pathway for liability. Then, of course, if they're involved in a contravention, then they're liable, and that's productivity partners is a pretty good restatement of accessorial liability in this context. And then in some cases, individual corporate officers have deemed liability. So regardless of their fault or otherwise, the mere fact that you are a director at the time the company makes the misstatement, you have deemed liability under some parts of the law. So again, multiple different pathways, all potentially giving rise to liability off the same facts for directors as well as for corporations. All right, now, this is a picture of porridge spilled on the ground. So I said we would come back to this. And this is, of course, Stephen's, Justice Rary's famous quote from the Wingecarribee case. And what people forget is what he's talking about here is whether he ought to apply the misleading and deceptive conduct provision in section 1041H of the Corporations Act, or he ought to apply the misleading and deceptive conduct provision from section 12DA of the Asset Act. And so there were lots of arguments, like lots of court time taken over. One applies in trade or commerce and the other one doesn't. One applies in connection with financial services and the other one applies to financial products and so on. Anyway, so by paragraph 3086 or whatever it was of the judgment, he was pretty frustrated. And he said, why is there a difference? Why does the court have to waste its time wading through this legislative porridge to work out which one or ones of these provisions apply, even though it's likely that the end result will be the same? So that was the question he asked. And my answer to that is it's actually worse than he thought, because the answer isn't the same. Right? If the answer was the same, then we could just say, well, that's a whole lot of redundant regulation and just cross it out. But the problem is that the answer is not the same, depending on which one you land on. And occasionally, of course, we love the federal court, but occasionally you will see in the federal court, for example, ASIC being chided by judges for over pleading things. Why did you plead this and this and this, and this? Why? And the answer is, well, you better not miss any of them because they all operate slightly differently for no good reason other than complex systems are highly path dependent. That is the only explanation. All of those different things that I showed you before are accreted over 30 years, and they were added by successive parliaments who didn't understand what the law already was, who added to it and then created this significant confusion. So let me show you the confusion. I'm going to show you some slides with lots of tiny writing on them, and don't worry about that too much. But as I do show you that, I just want you to bear these things in mind. The interaction between the context-specific rules, so the liability rule for a prospectus, for a takeover document, for a crowdsourced funding document, they exclude some of the general provisions, but not all of them. So the legislation manifests an intention, right, that, oh, well, we'll exclude the strict liability provisions, but we don't exclude all of the strict liability provisions, and that's the problem. So as we go through, just keep an eye on when the general rule is turned off and when it isn't. Then we've got some forms of mandatory disclosure that don't have any context-specific rules at all, and that's principally annual reporting. So there's no equivalent of the prospectus liability regime for annual reporting. It's just strict liability, always has been. But now we have sustainability reporting in there as well, and I've argued elsewhere. I think that's a different argument. So they're all entirely strict liability. And then where we have these different layering up rules, they have different fault elements. So some of them require proof of knowledge, some recklessness, some negligence, some are no fault. They have different consequences. Some are criminal, some are civil penalties, some are civil. Don't assume that criminal goes with intentional, civil penalty goes with, because that's not true. Like some of them are, for example, 1308, it's a criminal offence for negligence in 1308. And then some of them are strict liability criminal, and then some of them you've got a defence for civil in the same fact situation, which is very strange. Then there's a huge issue, and this is why I'm so glad we're all lawyers and we can have this conversation without anyone overhearing us. all of the provisions operate differently in terms of where the burdens of proof sit. So, for example, you'll see in a minute a section that says you're liable if, brackets, the prosecution can prove that you were negligent in preparing this document, or you have something that says you're liable unless you can prove that you weren't negligent. And of course, if you have that conversation with non-lawyers, they're like, what's the difference? But we understand there is a very significant difference between those two things. So this inconsistency around the proof of elements, the proof of defences, sometimes the defence has to be the defendant carries an evidential burden. Sometimes they actually carry a legal burden, which is a completely different thing. If there are safe harbours, who has to establish the existence of the safe harbour and to what standard and so on. So they're all inconsistent with each other. There's differences in the treatment of forward-looking statements. So to go back to Stephen Rary's question, why does it matter if it's misleading and deceptive conduct in the Corporations Act or the ASIC Act? The answer is because if it's a statement about the future and you make it under the Corporations Act, then the plaintiff has to prove that there weren't reasonable grounds for the statement. If you make the equivalent claim under the ASIC Act, you have to prove that you did have reasonable grounds for making that statement. So even between two otherwise identical provisions, has been described as such recently, you have this difference in terms of where the burden of proof and the onus of proof sits in relation to forward-looking statements. And then, as I say, if you get through all of those and you end up with a situation where there's been an investor who's been misled and has suffered loss or damage as a result of that misleading conduct, it matters which action you have put in your pleadings, because some of them, where it's pure economic loss, the plaintiff will have their recovery reduced for contributory negligence, but not others. Sometimes if there's more than one defendant, under some of these causes of action, my defendant will only have to pay their proportionate share and not the whole thing. But in other causes of action, they're all jointly and severally liable. So if the company's broke, the auditor's paying the whole lot, right? And some of them are covered by the professional indemnity scheme, you know, maximum liability in the professional conduct rules. Some of them aren't. So every time we criticise people and say, why are you pleading 11 different causes of action with respect to the same breach, it's because each of those things is different. And if you miss one of them, you can end up with a real problem. So these are the slides with all the tiny writing on them. What we're talking about here is I put something in the prospectus that wasn't right. So that's like, we put out a prospectus, we thought this, we said this, and it turned out not to be right. These are all the different ways in which the corporation can be criminally prosecuted in respect of that one fact situation. And as you'll see, I should have had a pointer. The first one, the prosecution can prove that you did not take all reasonable steps. Okay, so the burden's there. Then the other one is, oh, no, well, you're liable unless you can prove due diligence, so the burden's sitting over there. And then some of them are subject to knowledge requirements, some of them are reckless, some of them are negligent, and so on. So all different ways in which the same conduct can be the subject of different criminal prosecutions, as if they ever happen, with different consequences that attach in terms of the maximum penalties, ranging from 6,000 penalty units to 50,000 penalty units for the same conduct. All right, if you make that misstatement and it's in a prospectus and ASIC decides that they want to go after you for a civil penalty, then these are 4 different ways you can do it. The first 2 are strict liability and the second 2 are not, because the second 2, first of all, there's a negligence one, and then the 4th one is an intentional or reckless breach. So again, no calibration in the consequences. They're all 50,000 penalty units or 10% of turnover or whatever, including the 2 strict liability provisions at the beginning. And then for civil liability, all the different ways in which the plaintiff could seek recovery for a mistake in a prospectus. Strict liability, the first one. The second one, they're liable unless they can establish the defence. The third one is they're liable if the plaintiff can prove that they were reckless or knew or ought reasonably to have known that it was wrong, and so on. So again, different pathways, different level of fault, different burden of proof for the plaintiff and the defendant. And that's why you have to be careful when you're putting together the claim that you're not missing the more fertile avenue of recovery, which of course is the no fault. Now, just bear in mind, sorry to go back to the complicated chart that we had at the beginning, prospectuses have the specific liability regime, right? So they have here's a provision, section 728 of the Corporations Act, that talks about when a person should be liable if there's a mistake in their prospectus, right? But the problem is then it excludes some of the general misleading conduct provisions, but not all of them. And it doesn't exclude the securities offences, and it doesn't exclude the information failure provisions. So they can be a more fertile avenue for recovery for a plaintiff. Annual reports, because annual reports don't have a context-specific liability regime of their own, they're strict liability all the way down. It's turtles all the way down for annual reports, including sustainability reports, 1308, documents required under the Act, and then the false and misleading conduct provisions apply to statements that are in the annual report. So again, 1, 2, 3, 4, 5, 6 different criminal offences. All right, statements in an annual report, civil penalties, again, strict liability, the first one, strict liability, the second one. If you've got 2 strict liability civil penalties with a $500 million penalty, why do you then need a fault-based one, right? That's the point. So, and again, there's a fault-based one which is intentional, and there's a fault-based one that's negligent as well. And then this is if you like to sue people for saying that they're more sustainable than they really are, this is the slide for you. Get out your phone. If the statement in the sustainability report was misleading or deceptive, you've got the general action. Then you've got 12DB, which ASIC has used in this greenwashing context, 12GF, ASIC has used in greenwashing. And then you've got the general securities offences provisions as well, if they lead people to have a view about the nature of the securities, which is not accurate. All right, so we've talked about prospectuses, we've talked about annual reports, continuous disclosure. Continuous disclosure, for those of you who've been playing along since the pandemic, was the subject of some law reform that was intended to introduce a requirement that a plaintiff bringing a class action, usually alleging loss resulting from some defect in continuous disclosure, had to prove a fault element. That was the intention. I'm very disappointed well, depending on whether you're a plaintiff or a defendant side person, I'm neutral to tell you that it didn't work. So anyway, this is what we've got at the moment. If you are supposed to disclose something and you just don't disclose it, so it's a pure omission, then the context-specific rules apply. If you knew or were reckless as to whether the information that you didn't disclose was price sensitive, then that's a criminal offence. It also gives rise to civil penalty liability, and there's a new or were negligent has to be established for the claim in the securities class action. However, if I make a statement to the exchange purporting to discharge my continuous disclosure obligation, but it's got a mistake in it, so there's an omission, or, you know, I forecast a certain ore body and it turned out not to be right. If there's a mistake in it, that's strict liability still, same as always, and the securities offences provisions apply, and the information failure provisions apply as well, because it's a document that's required under the Act. So even within the same regime, there's inconsistency. So it's not just across the different disclosure settings. Within the disclosure settings, there's inconsistencies in terms of how you plead the nature of the defect. That's the basis of the claim. So you can see why securities class action lawyers earn their money. All right, so could you fix it? Now, this is where we're going to have the good conversation. You could fix it without upsetting the apple cart, like without challenging the more theoretical question about liability and rule design. You could just fix it by saying all the ones that have that 1991 context-specific liability rule, like here's the liability rule for prospectuses, and they carve out some of the general provisions, but not all of them. We could just say, let's just carve out all the general ones and just have the one rule, right? Let's go back to what we had in 1991 and say, if it's a prospectus, this is the rule, it's a code, none, you can't argue anything else, you're either this or not. Then we could say, well, okay, that's 5 of them, but what about the other 3? And I've listed them there, like annual reports, notices, cleansing notices, continuous disclosure notices. Should they have their own context-specific liability rule as well, which is not strict liability, and we can argue about that. So you could do that, and then you could say, well, if we've got context-specific rules for all of them, should they all be the same? Like, is there a good reason why in a prospectus you should have a due diligence defence but not in a continuous disclosure notice? Like, what's the policy? And then if you can sort all that out and you say, do you know what, corporate disclosure is actually, regardless of the setting, it intuitively should be subject to a coherent liability framework, then you could just have one liability framework and you could just list all the corporate disclosures that apply to it. And then you could reduce, I counted it, although Andrew will know much better than I, and you can reduce the length of the Corporations Act by like 48 pages or something just by doing that. But you have to make some policy choices at this point. So whenever you have this argument with people, they're always like, well, you know, corporations should have strict liability for disclosure failures. And to which I reply, I'm agnostic, right? I don't care. But if you're going to have a strict liability rule, get rid of all of the others. Like, just pick one. I say I'm agnostic, but I'm not fully agnostic because this is what I think it should be, right? I think a corporation that is required, not choosing, I'm not talking about voluntary disclosures, which should be covered by misleading and deceptive conduct, no argument there. Mandatory disclosure, if they set out deliberately to mislead people, that should be a criminal offence. Tick, right? Go to jail, go directly to jail, do not pass go. Civil penalty, $500 million, rakes through the courts, 15 years, all of that. Sure, but maybe subject to a due diligence defence. Now, why would you do that? Because that sends a message to the market that they are expected to invest corporate resources in doing the sort of diligence that will verify and support the disclosures that they make. So they have to, they're incentivised because there's a defence to systematically develop their disclosure through a proper process. Now, we can argue about these. People have different views about whether these settings are right. Civil liability, I think if a corporation puts something in a prospectus and you're misled and you lose money as a result of that, it should be liable for that. Traditionally in Australia, we've said, but you get a due diligence defence or a reasonable reliance defence. Sure, good. Traditionally in Australia, we've said around continuous disclosure, well, we actually want people to prove fault before they can sue on that. This is just a balancing exercise. Like, tort law is just balancing who best. There's a loss, somebody's got to carry it, who most efficiently carries it. There's a question of fairness as between the defendant and the plaintiff, and there's also a system question about the extent to which defensive sort of managing liability risk is a drag on business spending its money on other things, put it as simply as that. So you could, like, these are all just suggestions. This is how I do it. If you mean it, you should go to jail. If you're not careful, you should have to pay a civil penalty. If you hurt somebody else, then you should compensate them, but probably subject to due diligence or some kind of adjustment because no disclosure regime is perfect. I hate infringement notices. I'm on the record. I also have famously said many times that civil penalties are a cancer on the regulatory system, so I'm used to overstating things. We shouldn't have infringement notices for things that involve the exercise of commercial decision-making. Whether something's material or not is a commercial decision. Infringement notices are just a bribe that people pay to make regulators go away, and I object to them on principle. All right, so what should the individual liability be? This is always more controversial. If there's dishonest conduct, it should be an offence. Otherwise, if I'm involved in the contravention in a productivity partner's sense, I should be punished just in exactly the same way as the corporation. No problems there. I and my co-author, Tim Bednall, 15 years ago, argued that there ought to be an affirmative due diligence obligation on corporate officers to ensure the accuracy of disclosures. So a reasonable steps duty to make sure, like 344, that the disclosure is accurate. But I don't think the duty of care should be a civil penalty provision. I just don't. I don't understand why corporate directors are the only occupational class in Australia that can be punished by the state for negligence in circumstances where it didn't cause anyone any loss. The corporation, which is the entity to which the duty of care is owed, has no issue, doesn't want to sue them, and yet we allow or expect our corporate regulator to sue people for negligence. If you applied that to a partner of a law firm, a judge, a minister, the head of the public service, the person who ran robo-debt, right? None of them can get sued for negligence in those circumstances, and I just think it's unhelpful. There's an interesting paper that's just been published by the AICD on comparing directors' personal liability in Australia with all the places overseas. So if you're interested in that, I can send you a copy of that. Right, this is my last slide. Oh, my second last slide. Right. Okay, so if you accept Stephen's comments at the beginning about why complexity is bad, and you accept that I've demonstrated complexity here, then I may have persuaded you that we should rationalise this, right? It would be easier for people to know what their obligations are. It would be easier for plaintiffs to sue people. It would be easier for ASIC to punish people. It would operate as a more effective deterrent and so on. If I've made the case for that, then we get to this point and people go, but will it ever happen? Somebody, when we talked about this before, pointed out to me that there's a mistake in the provision to do with payment of dividends in the Corporations Act. It's been in there for 30 years and everybody knows there's a mistake in there and they've been trying to fix that and they haven't been able to fix that in 30 years. So having this argument may be fairly pointless. Anyway, here's where we go. Here's where I got to. Explaining the problem of complexity in Australia's omnibus statute, no matter how eloquently, and I say that with sending all love to the Australian Law Reform Commission, doesn't help, right? Nobody's slapping their forehead and going, thank you, Pamela, for pointing out how complex this statute is, right? Nobody's going, well, now you've shown me, I better get some time in the parliamentary calendar and clean that up, right? It doesn't matter. Stephen Rary said it on my birthday 11 years ago. ALRC said it 4 years ago. I've said it. Banking and Finance Royal Commission said it, right? We've all said it. Everybody gets it. Here's the second thing. Astonishingly to me, as chair of the Business Law section of the Law Council of Australia, everybody out there thinks this is our fault, right? Everyone's like, well, that's lawyers. Going back to Bentham, let's go back to the 18th century. Well, it's lawyers made this problem. And lawyers profit from this problem because there's a whole lot of people like Elizabeth used to be sitting at the bar table trying to explain to the judge why you have to plead both the ASIC Action and the Corporations Act, even though they're both misleading and deceptive conduct provisions, and then you have to plead all the specific stuff as well because you might get proportionate liability under one, right? So they blame us for it, and that makes me cross because we have pointed out this problem many times, many times. So is there a glimmer of hope? Weirdly, from the Productivity Commission, which is very rarely a source of hope of anything, they put out a report earlier in the year and they said, maybe it's a political problem. Maybe the problem is politicians and bureaucrats and regulators, Every time there's something goes wrong, like what's coming in private credit, oh, someone ought to do something about it. We ought to pass a law. We ought to have bigger penalties. We ought to have dual track regulation. We ought to have tri-track regulation. You know, we ought to make it easier for ASIC to get all these enormous penalties without having proved fault. So we just pile all this stuff on. And that is exactly the story of what happened here. So if you go back to the halcyon days when we were probably still all in law school, you know, in the early 90s, and it was like, okay, we're going to make a principled decision about liability for defective disclosure. And then they just added all this other stuff on without ever checking how it integrates with the rest of it. And now we've just got this terrible mess. So what are we going to do about it? Here's the advertisement. I think our best chance is to all get together and say to the government, we need to fix this. And we need an expert body. You don't have to fill it up with lawyers. You can have investment bankers, and people from Deloitte will bring their AI and help you. You can get, you know, the business council and everyone to come along, and we'll put together, I don't know, we could call it CAMAC, you know. So we need an expert body that goes across more than one parliament, that is non-partisan, is given a job to do, is given parliamentary counsel, because there's a huge problem with no drafting capability left in the public service. It's all just been hollowed out and gone. And just say to them, don't worry, politicians, go do whatever you're doing. Give it to us. We'll just sort it out when we get agreement, broad agreement amongst all the stakeholders about how we can take this forward. We'll come and give it to you, and then you can enact it or not at your peril. So there's something called the Corporate Law Reform Alliance, which is pronounced clearer, if you're wondering how you pronounce that. And that's a lot of peak bodies, including the business law section, the governance institute and so on, that's arguing for some way of getting around this. So don't despair, right? Don't despair. Thank you for listening to my rant about all of the different ways in which people can be sued for defective disclosure. But the point is, its inconsistency makes me a little nutty, but it wouldn't matter if it worked, right? The problem is it doesn't work. It takes up a lot of time and resources, and it's not producing good quality corporate disclosure. It's producing defensive, you know, mealy-mouthed, whatever, disclosure. So let's have the argument. Thank you.
Thank you, Pamela, for that very engaging presentation. I have to say that I've had the benefit of reading the written paper, which is a veritable tour of foot to force, which I would recommend to everyone in its ability to combine a careful and thorough analysis of these complex, detailed maze of legal provisions, but combine that with a big picture critique of what the provisions are designed to achieve and how that might be done more coherently. Now we have a little bit of time for questions, if there are any questions for Pamela. Yeah.
Thanks very much, Pamela. I think you've made the case for reducing complexity and overcoming the incoherence that exists. I think the issue, as you noted, is just no one knows what the policy setting should be. There's just no clarity around the policies. It's what Commissioner Haynes said in terms of not knowing the purpose for which the rule was drafted, not being able to connect the rules with the norms, your reference before to the hortatory purpose. But I do wonder whether there's also an argument, just to play the devil's advocate, as an argument that incoherence and complexity act as a deterrent. And therefore, if we made it more simple, we'd have more problems. And in terms of costs, that's just a cost that business has to accept. And lawyers seem to be doing well out of it all. So why are you complaining? That's not a view that I hold, but it's just an interesting argument that you might get from others.
I think the point that Stephen made in 2014 and that the Law Reform Commission made again in 2023 is it's not just the compliance cost, right? It's also the enforcement cost. So that's an enforcement cost for plaintiffs. So imagine, I think some people, maybe I shouldn't mention this online, but I was the expert witness in the REST case, one of the first climate change cases for the plaintiffs in that case. And So, you know, these are civil society organisations, often funded by donations, with lots of experts and lawyers that they have to pay and so on. So having things that are expensive to enforce interferes with the capacity of plaintiffs to exercise their rights sufficiently, although now they can just get AI to act for them, so that's fine, because apparently that's not a breach of the legal practice rules. So it's not just a compliance cost, it's also an enforcement cost. And the other thing I would say, I've said this in the sustainability context, because I've thought a lot about sustainability reporting. I'm in favour of it, but not in favour of the rules as they're designed in Australia. So my article talks about that. Having this incoherence doesn't make people do a better job because they're frightened that they can't manage their liability risk. It actually produces worse disclosure, right? Because people don't, you know, you kind of like, well, who's driving? If you read somebody's sustainability report in Australia.
It's liability management.
Yeah, it's just a liability management thing. And even if you think about just prospectuses, right? So prospectuses are supposed to have this dedicated liability, which was carefully argued through the 90s about where the balance should sit. And I know people have different views from mine about the policies, but at least let's have a policy. In a prospectus or in a PDS, you have to put what's called, you know, statement of risks or something like that. And when I taught here at Melbourne Law School, taught managed investments and financial services here for many years. And I used to always just give my students for their assessment an actual ad from an actual product that was in the market. And I was always like, is this product compliant? They're all like, oh no, they can be sued 500 different ways. And I was sort of like, okay, opening the can. But anyway, the problem is that I gave them one problem and I said, look at the risk statement in the PES. One of them is for like this highly leveraged real estate hedge fund, and the other one is for like a PIMCO bond fund, like as vanilla and as risky as you could get. And they both had the same risk statement because a pack of lawyers had drafted it and it said things like investments can go up and down, you might lose your money. Like it was just ridiculous. Like you had no way of knowing that one of them was in some kind of mezzanine debt in a property development project on the Gold Coast, and the other one was basically a government bond. And yet, so it's that's the real cost. It's the cost to the efficiency of the capital market from having bad laws that make people behave in the way that they do, and then people end up in the wrong money. So this private credit thing, right, I'm calling it. The report that ASIC just published said all of the funds that have institutional investors in them that are run by big overseas managers, they're all great. Everything that's got retail money in it and so-called sophisticated investor money because they refused to move the thresholds, right, last year, they're all terrible, right? They're all a state mortgage. And so that's regulatory failure, right? The unregulated product's great because the investors in that product have the sophistication and the bargaining power to get the disclosure that they want. And the retail end, the regulation doesn't work, right? They're not getting the disclosure that they want. And the last time ASIC updated its guidance on what should be in a PDS for a private credit product was 2012, right? And I'm very embarrassed to say that that 2012 policy was one that I wrote in 2009 when I worked at ASIC. So, and that was after all the Gold Coast mortgage funds fell over. Yeah, so I think that's the cost. That's the long answer, but there is a cost to this, and it's a cost to the efficiency of the capital markets.
I'm just looking at the time, Pamela, and I feel like we might need to draw this to a close and have other questions informally afterwards. But thank you. Please join me, everyone, in thanking Pamela for a tremendous presentation.
Thank you.